I've been thinking about lawyers this morning. A professional advocate hired to bend the law on behalf of a paying client, and for this reason, consider the most suitable background for entry into politics. Roy Moore, of course, is from that class of people as a representative of the courts, and now he's seeking in the federal jurisdiction to enter into the legislative branch by running for the Senate, and an honorable and remarkable man who stands on principle and refuses to be bullied. He is someone whom I would offer to you as an example of what you, my listeners, should be. And that is not intimidated and not willing to bend on principle, right? The principle that you have is not one against which you will bend. And then you also have a separate principle about not bending. Okay, so you have two principles involved there. And one is that if you have a right and you're innocent and harmless and good, then you cannot be coerced into doing something that is against your conscience or which requires you to sign and agree upon things which you cannot that you cannot agree to without perjuring yourself, right? And that the fact that you have to sign your name on things which connote or invoke the penalties of perjury is in your favor. It's in your favor that's there, so that you won't ever sign anything that you don't fully understand every legal point regarding. You do not sign anything for which you do not understand the meaning of every word and every concept, which, of course, in these documents that you sign are freighted with legal signification. You think that only common meanings apply, but in fact, these are legal significations written by lawyers in the government employ. It's wise to say nothing, to not sign your name if you don't know everything that these are these lines are saying. And Michael Flynn made that mistake. He talked to investigators, and that's the last thing you ever want to do. Don't ever talk to investigators or police officers or deputies or regulators ever, because what they do is they trap you. And if the questioners are two FBI men, there's no recording allowed. And their form is the final record. And whatever they say, whatever that the transcriber puts in that report, that is the legal record, and that is what happened, and that is what you said. And in that reporting, you will be trapped, and you will incriminate yourself. And so, the answer requires some courage. You might say some temerity to the answer to the question of, can we talk with you? You are in trouble, and people you know are in trouble, and you better talk with us, because we're going to get them with or without your assistance. That is the threat. And the promise is always, you can make things better for yourself and for your son or your friends or your company if you cooperate. But that is always a lie, always a lie. How many people have been indicted for lying to investigators? It's a Martha Stewart going back, and then people since her trapped in their own words. And you have a right to say the following. And this is the safest and gives you, lets you keep a clean heart, right? And lets you not fall over your flapping gums. If you have something against me, get an indictment. That's what you have to say. Get an indictment. If I've done something wrong, get an indictment. I'm not talking with you. That is the best thing. If you want to read my papers, then get a warrant. Okay, that's what you have to have. Get a warrant for a search. And otherwise, get out. Get out of my house. Get out of my office. I'm not talking with you. Okay, that's what you have to say. And Michael Flynn didn't do that, right? He's a very smart man, but he was intimidated out of his innocence into making statements that were calculating. And as President Trump just says, well, he lied. Well, I don't know if he did or not, but in any event, the indictment or the information against him was that he lied, and so he's pleading guilty to that. So that is what you face if you talk to cops, any cop. Okay, COP is citizen on patrol. Any cop you talk to, whether he's dressed in federal regulatory garb, tax officials, or other, you're not obligated to answer any questions. Okay, you are free to say nothing. Say nothing. I do not talk to police is one title of the lecture online. from a university professor on this very point. It can only hurt you. It cannot help you to talk. It simply cannot. And you cannot talk your way out of an indictment. If it's coming against you, believe me, it's coming against you. And talking it through and helping the officer is not going to assist you in the least. And that is the prudent man, right? The prudent man, the prudent man says nothing. And even the fool who keeps his mouth closed appears to be wise. And so here I would say, if you're a fool or if you're wise, the closed mouth is better for you. Now I have two correspondents in the prison system, and I'm very glad to have them. One is named Robert Whipple. The other one is Grenda Ray Harmer, in, I think, for 25 years on aggravated robbery and maybe something like aggravated assault. Not sure now exactly what he told me about the cause of his entry into this penal slavery, state slavery allowed under the Constitution. We have slavery in Tennessee permitted, and state slave system is overseen by Tony Parker, TDOC Commissioner, Tennessee Department of Correction Commissioner. And I want you think I have a lot to get to you. Part of this is the color of my correspondence, and then the other part is the reasoning of his efforts. The reasoning of his efforts is a kind of legal discussion. Okay, so you might say, well, I really don't want, I don't want to hear David Tulis when he talks about Christianity. And I really don't want to hear David Tulis giving discussion about what might work in courtroom or in a conflict with the good people. But Grenda Ray Harmer has been thinking about these issues as I've described them to him in letter. And my correspondent on November the 28th submitted a 2-page administrative notice. Now, let me tell you a little bit about what's in this notice to Tony Parker. It is essentially a complaint about conditions in the jail. And you've heard some of these points before. He's a very fine writer, and he's a very nice handwriting. I don't know if you can see it on Facebook. We are, by the way, live on Facebook at Nooga Radio. Of course, the type is backwards, but you can see how neatly he writes. If you're watching us on YouTube, you can see just for a second there, as I hold up my letter from him to the screen, how neatly he writes. It's almost as if it were typewritten. But he says this administrative notice provides legal notice Warden Phillips allows Morgan County Correctional Complex staff to violate above-mentioned statute and TDOC Morgan County policies. Failure or refusal to act in good faith and correct the unlawful conduct denies you qualified immunity under legal standard Anderson versus Creighton. And he gives the citation, U.S. citation at 1989, of whether a reasonable person could have believed under the circumstances his actions were, quote, lawful in light of clearly established law. So he's giving the reason for this document. And that is, he's essentially saying you don't have qualified immunity if you've been given notice of crimes and offenses on your watch or conduct made by you, okay? And there are he's giving some facts here, reports 5 facts. So let's just tell you one of them. One of them, for example, is fact number 4, TDOC policy, and he gives the citation 404.09, numeral letter 6G1, policy number 404-1, and so on. Requires, he goes on to say, requires staff to be, quote, aware of a change in circumstances which may present a reason for an inmate's release from protective custody. Now, protective custody is what they do to troublemakers like my correspondent. This isn't being done because Counselor Cowherd, Corporal Wallace, and MCCX PC committees sit in their offices doing nothing. For example, on August the 16th, 2017, Counselor Cowherd asked Christopher Davis, number 398102, where he could safely be released into general population, which Davis told him 2 prisons. When nothing happened, Davis wrote Nashville, as I suggested. On October the 5th, Chief Counselor Jeffrey Nance wrote Davis stating he, quote, could not find where Davis had requested a transfer, though Davis through Davis's assigned counselor, end quote. Mr. Cowherd never put in the paperwork because he's lazy. Warden Phillips allows this to ensure PC unit remains as full as possible. PC, again, is protective custody, and that's solitary confinement. Okay, solitary confinement for your own protection, right? That's Brenda Harmer, I believe, is in this circumstance. And he goes on. He gives another one about the tobacco policy. He cites the law. You might say the policy in detail. The citation takes up one whole line. Okay, I won't read it to you, but it goes on to say that this rule prohibits tobacco and provides enforcement on government property. MCCX security is allowing staff to bring smoking and chewing tobacco into MCCX to use during their shift. I've personally witnessed on PC unit, Corporal Wallace, Officer Williams, Corporal Perry, and Officer Flannery violate the law by chew tobacco and spit juices in office trash can or in styrofoam cup while serving food. Oh, that sounds appetizing. To keep from being told on, they permit inmates to get chewed tobacco out of a tray can to dry out and smoke. Okay, hear that? Christopher Davis, so on, said he saw a fat lieutenant go in Unit 1 restroom for staff. When he came out, he smelled like cigarettes. So smoking is taking place. So here we have a whistleblower. Okay, whistleblower. And what's important to note is the form. He's using the form of administrative notice. Now, I have a high view of this form of documentation because it gets results. Now, he confirms this in an earlier admin notice. He got an unusual letter. I'm holding it up here for you to see. It's in Geneva type, or Helvetica type, and it's from Warden Sean Phillips. It's a response to a November 10 administrative notice. It says, this memo is in response to your administrative notice, in scare quotes, to my office. Your request, okay, there are 4 points. Due to departmental and institutional need, the cell will not be changed into a kitchenette. Number 2, the kitchen staff will monitor the temperatures of the food more closely because he had complained about food being cold. Food is served at the correct portions per the statewide menu. And number 4, due to departmental and institutional need, the capacity of Unit 1 will not change. Now, those are in response to objections and questions that he had asked. Now, notice that he says he got a remarkably quick response. He says, I'm sending it to you so you can make a copy for yourself. I need it back for a future lawsuit, he says. But my main goal is in showing it to you is so you can see the response for yourself. He says, my November 28 admin notice you'll be receiving this week. Of course, that's the one I just read you from. It'll really perk your interest. We both know Nashville will deny everything. Before letting Nashville know of the enclosed response I got, you ought to contact Nasa Taylor, the FLAC, for a comment. Now, just here's what Brenda Harmer's doing wrong. Okay, let me just tell you. He's impatient, and that's what administrative notice requires, patience. And here's why. Administrative notice. Well, hold on. You say, well, what do I care about this? Okay, well, let me explain why this is important. When you're having a conflict with a bureaucrat, you need to remind him of his authority, right? He has express authority in the statute to do certain things. The authority that is expressed also limits what he does, okay? You got that? When you're being assailed or attacked by somebody as a state actor, the person, I would say probably 80% of the time, is acting outside of his authority. I know in my case, the commissioner of safety made a demand upon me to go and get a social security number to get a driver's license. I said, well, I don't have one, and I'm not going to go and get one, and you can't make me. And the legislature changed the law, fearing that my litigation would overturn the whole statute, and so it changed the law. But I used in that conflict administrative notice to great effect. For example, I got the state to address me in my personal natural capacity, not as David Jonathan Tulis, the corporation, styled in all capital letters, but David Jonathan Tulis, the human being, capital D, small a, small v. You get it, right? Capital J, small o, small m, and capital T, small u. Right? That's the human being, and that's in fact the name on my birth certificate, David Jonathan Tulis. And so this does have effect, and because it's administrative, it lays out an important groundwork. Now, Brenda Harmer is learning about this. So what he has here is really a quasi or hybrid admin notice. And I'm going to tell him, I say, Brenda, this is not this is not quite what you want, even though you seem to be getting results from it. A real administrative notice goes deeper, and it doesn't worry about the details of the current troubles that you have. And so that's what I've been suggesting to him is that your admin notice is a review of the authorities controlling that state actor. Okay, starting with his oath of office and going down into the details. And what he points out rightly in his document, this hybrid administrative notice, that if the official is properly notified of his authorities, apart from any particular dispute, right? If he's notified apart from a particular dispute of his authorities, both the requirements and the prohibitions and the limits, then you can have him. You can have him when the abuses take place because you've given him notice, right? And what you've done is you've denied him the good faith defense. You've denied him, I'm sorry, I didn't know that I was violating the rule. Wasn't aware of that. And that defense is no longer available when you sue for $5 million or you sue for his house, right? If you sue him in his person, you can take from him his estate for damages done to you. And that can be even if you're a prisoner. I'd say even if you're a prisoner, if you've given proper notice to a state actor and he's been properly notified, there's no immunity. There simply is no immunity. Now we have, and I'm going to say, I say that in pencil because there is a kind of total immunity. State actors they can do virtually no wrong. There is a judicial immunity for judges. They can commit no sin, right? They are effectively the representatives of God. God walking on the earth through the modern state. So they have a kind of immunity. And it's almost impossible to reach through his authority to the man of the judge. I think it's really impossible. And it would not be allowed to stand by any court in our state. And yet still there are others not quite as high, commissioners, mayors, and sheriffs, police department officers and the like. They are not free from these claims. Now, what I'm trying to tell you is this: that here's a remedy, but what's the idea behind it? The idea behind the remedy is local economy. What it does, it personalizes the law to the individual actor in your city, right, in your county, here in Chattanooga, here in Hamilton County, or in your place if you are just traveling through, enjoying our rainy highways today, passing through the ridge cut on your way south or west. And administrative notice is the way in which you deliver the law to the state actor. And if it's a comprehensive notice, which it would include court opinions and court rulings on a particular provision of the law, you've sewn up the matter. Okay. Now the temptation is to be impatient. Now, and I think my prison inmate correspondent is impatient to have in his admin notice facts in dispute, facts which are alleged as part of the grievance. So there's a distinction. There's one document that's the administrative notice that lays out the law. And then there is a separate document or set of documents which are the grievances. And what you're doing is you're tying the official to the law, right? You're tying him into the statute, into the policy rules of his department. And then you're pulling him away from obedience to those rules by looking at all the facts for which he's responsible. You see what I'm saying? And in making that separation, pulling the actor out of the rules and showing that he is beyond the rules, outside the rules, above the rules, beyond the scope of the rules in his activity, he is acting in his personal capacity. So what? Well, what you're doing is you're making his oath come alive to him. You're making him dread to offend God by reminding him of his oath and making him dread violating the holy scripture, the holy writ, if you will, of law that is his authority, the holy writ of policy in his department, which also he is sworn to uphold. Now, those policies in prisons are voluminous, no doubt. There's like a separate code of policies. But there, too, you can show, if you have a proper notice, you can show bad faith. You can show a vengeful attitude. You can show that the state actor is acting willfully, that he's acting malignantly against you with evil intentions, right? With careless and vile disregard for his subjects, right? In this case, the subject is the prisoner, or the victim, or the target, or the regulatee, or the member of the public who is, in other circumstances, the target, the one in view of the state actor with his enforcement mechanism, his guns, right? His threats, his legal papers, his claims against you. These are often done, you might say, in ignorance. But if you give proper notice, it can't be it can't be in ignorance anymore. It has to be done willfully. So what will happen is, I suggest that if you give a proper notice to an authority of his authorities, your crisis may dry up. It may simply dry up, and you'll hear nothing further about it. But that requires some legwork. It requires some reasoning. And what you're doing is you're making the individual human being who is the officer with his cloak of authority suddenly realize that cloak doesn't cover him entirely. That he is personally exposed, and he has to do what's right. He has to do what's good and true.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM.